Twice Quickie. From 1789 to 1922, citizens of the U.S. were protected by the Fifth Amendment from double jeopardy, being tried twice for the same act. And then the Supreme Court destroyed that in United States v. Lanza. It's one of the horrible decisions from the Prohibition era that we still have to deal with today. Individuals were indicted for making and transporting liquor in both federal court and a Washington state court. The defendant said that constituted double jeopardy, and the U.S. District Court agreed, dismissing all 5 counts. But then the Supreme Court unanimously overturned that. Even if you've already been tried and punished in state court, or even if you've been acquitted, you can still be tried in federal court. The opinion from Chief Justice William Howard Taft said, "We have here 2 sovereignties deriving power from different sources, capable of dealing with the same subject matter within the same territory. Each may, without interference by the other, enact laws to secure prohibition, with the limitation that no legislation can give validity to acts prohibited by the amendment. Each government, in determining what shall be an offense against its peace and dignity, is exercising its own sovereignty, not that of the other. It follows that an act denounced as a crime by both national and state sovereignties is an offense against the peace and dignity of both and may be punished by each." This is known as the dual sovereignty doctrine, and it still applies today. Even though it has no textual support in the Constitution, no one had thought that was the case for over 133 years, and our founders clearly didn't think that. In fact, many times the courts had to put a stop to successive prosecutions from federal and state courts. To get around the Fifth Amendment, the Taft Court had to ignore the 14th Amendment and everything that had been decided subsequent to it. The Fifth Amendment, like all the other guarantees in the first 8 amendments, applies only to proceedings by the federal government, and the double jeopardy therein forbidden is a second prosecution under the authority of the federal government after a first trial for the same offense under the same authority. So, thanks to this decision, double jeopardy isn't double jeopardy when it moves from federal to state court or vice versa, even though that's the exact sort of situation the Fifth Amendment was written to prevent. In fact, it was even expanded in 1985's Heath v. Alabama to say that the person could be tried in multiple states. If you're wondering about other decisions of the Taft Court, they also helped establish the legality of minimum wage, said that citizens of U.S. territories don't have constitutional rights, ruled against free speech in Gitlow v. New York, affirmed Plessy v. Ferguson, and upheld warrantless searches of people's cars. Makes you want to eliminate all the precedents from the early 20th century.